Our final session, which is on church discipline, past, present, and future. And if you are listening in on the last lecture, you know I've already started talking about the past, and we're on the cusp of the present with the release of the new Title IV. And I'll be saying a little something about that. But I wanted to remind you of the purposes of church discipline. But let's start with judicial government in the Anglican Church in North America. And, you know, again, I want you to think about checks and balances. We do have an executive body. That's the Archbishop and the provincial staff. We have a legislative body. That is the Provincial Council and the Provincial Assembly. And we have a judicial branch, and that's at the ACNA level, the Court for the Trial of a Bishop, and what we call the Provincial Tribunal, which is actually a kind of Supreme Court that we have that makes final decisions when there are challenges to the lower court on what's going on. So here's the purposes that we state in our canons for church discipline. It's to protect the flock, to redeem the fallen, and to maintain good order. But I want you also to be aware of this statement, which I've referred to, and it's well worth listening to and reading out loud because it sets very clearly internal church law as being unique in its purposes and different from the kind of adversarial civil and criminal law that most of us are used to in the American system. So let me read this from the Church of England's report of the Archbishop's Commission on Ecclesial Courts, and that's 1954. Church discipline means a great deal more than maintaining good order. The true meaning cannot be adequately appreciated unless we think of it in terms of Christian discipleship. Through its courts, the church exercises discipline over the disciples of Christ in order to make them better disciples. The sentences which its courts pronounce have a twofold aim. Firstly, the bringing of a disciple of Christ who has failed in discipleship to a sense of spiritual realities by making him do a suitable penance. And that penance might be a censure or a set-aside, an inhibition. It might be learning something and doing something to make up for a wrong. It could mean setting them aside for a period of time. It could mean saying, I'm sorry, but you can no longer function in holy orders. You still are loved by Jesus and have a place in the life of the church, but you're going to have to do it now as a layperson. Secondly, where the disciple is an officer of the church, removing him from office so as to prevent him from being a hindrance to others in the path of Christian discipleship, which is just saying what I just said. Okay, so let me take this down for a minute and then go back to our Constitution and canons, because we're going to be looking a little more at the present and then at what the new Constitution and canons in Title IV have to say. So let me just repeat again this very fundamental issue, and that is that priests and deacons are disciplined in the courts for the trial of a deacon or presbyter in the diocese. So all of the discussions that you hear online about, oh, this new system is going to be too expensive, too costly, it's going to overwhelm the province. Well, it will be costly, no question about it. There's going to have to be people paid to make sure that everybody in the reports investigation committee and the investigations themselves, that everything is done decently and in order. But the only people that the province is going to be disciplining are bishops. Let me say that again. The only people the province are going to be disciplining are bishops. So there's going to be a finite, of necessity, I hope, a finite amount of complaints against the bishops. Now, where are bishops currently disciplined? And I'm going to take you to pages 34 through 36 in our canons. And basically, currently, they are disciplined in the courts for the trial of a bishop, which talks about 3 bishops who are members of the college, 2 presbyters, and 2 adult confirmed members, elected by provincial council by order. In other words, the lay order votes for the laity, the clergy vote for the clergy, and the bishops vote for the bishops. It's the only place in our current canons where we have that kind of voting. Okay? And there are alternates that are provided, and the senior diocesan member of the college, by date of consecration, shall be the president of the court, exclusive of the bishop under trial, and any bishop who may recuse himself. We don't really have a court of extraordinary jurisdiction. That's become obsolete for a variety of reasons. So it's never actually been convened. And concerning the Provincial Tribunal was designed actually in response to what happened to many of us in the Episcopal Church when we left. We found that bishops in the Episcopal Church disciplined us under the canons and did so by interpreting the canons in ways that tortured the Episcopal canons themselves. So, for instance, the canons for renunciation in the Episcopal Church at that time were that you had to write a letter of resignation specifying that you were resigning from holy orders. My Episcopal bishop at that time said, by virtue of your letting me know that you are transferring into the Church of Uganda, your holy orders are extinguished. Now, had we had a provincial tribunal in the Episcopal Church, I could have appealed that as a misreading of the plain and grammatical sense of the Episcopal canons, but we didn't. And so the whole goal of a provincial tribunal was to create a kind of Supreme Court that could say, this is how you actually interpret a canon and what it actually means. Now that becomes very important in the Ruch case, which I will explain in a minute. And then it has the jurisdiction as a court of review in the case of a conviction, so it has appellate jurisdiction. But it has original jurisdiction to hear and decide matters of dispute arising from the constitution and canons of the province. And then this last phrase, except in Title IV prior to the role assigned to it in Clause 1. Well, that last phrase didn't exist when the Ruch trial began. And so people could take an interlocutory appeal directly up to the provincial tribunal even before the court convened itself on a matter that they felt was being misinterpreted in the canons. Okay, and then it goes on to say, above B, to hear and decide disputes between dioceses, to hear and decide appeals by a bishop on issues of incapacity, and to issue non-binding advisory opinions on issues submitted by the college, the provincial court, or the provincial assembly. Now, so you've got an appellate jurisdiction and you've got an original jurisdiction. Now, this changes under new Title IV, and it changes in some important ways. I won't go into all of the details, but to say that essentially it has the same appellate jurisdiction it had before to hear appeals by people who've been convicted, clergy and bishops, in a court for the trial of, at the diocesan level, a presbyter or deacon, at the national level in the court for the trial of a bishop, on the grounds that the court committed an error in its proceedings, it didn't weigh the evidence properly, The facts didn't support its ruling. The sentence was too excessive for the crime. But it also has the right in this new investigative process that is not so adversarial. At any stage of the investigation, as the people who are doing the trial court, the bishop, priest, and deacon who are trying to get to the bishop, priest, and layperson are trying to get this panel, trying to get to the facts. At any point, as the proctors, the attorneys in this system, are arguing it out and trying to get to the facts, any one of those proctors can petition the provincial tribunal for what we'd call an interlocutory. It's like an intermediate in the middle of appeal to the provincial tribunal if they think that the panel in the court has made a bad decision. And the provincial tribunal has the authority to correct that. Okay, so that's a way of streamlining things and avoids all of the questions that were raised in the Ruch case about whether the provincial tribunal should ever have been involved at all. So that's where you have where bishops are disciplined. Now, how are they disciplined? Well, let's go back to pages 32 through 33 under the current canons, okay? And that has to do with presentments. And a presentment has to be by 3 bishops with jurisdiction or by not fewer than 10 presbyters, deacons, or adult baptized. That's the requirement for a presentment. That has been eliminated, okay, because now a report goes to an investigative committee, a standing investigative committee that investigates this, okay? 1 presbyter, not fewer than 6 laypersons, shall belong either to the diocese in which the alleged offense was committed or to the diocese in which the bishop is canonically resident. Such charges shall be in writing, signed and sworn to by all the accusers, and shall be presented to the archbishop, the archbishop's delegate, or the college of bishops. Well, of course, this was a huge problem because how do you make a presentment to the whole college of bishops? Particularly if you don't even know what the emails of the bishops are. Okay? And how do they gather together and say, oh, okay, so then it falls to the archbishop, and he has to respond to all of this and appoint a board of inquiry, all right? And this is part of the problem that happened under the existing canons. So you got a presentment. Okay, written charges have been made. Here was the problem in the Ruch case. So in the Ruch case, it's, they had 3 bishops sign the presentment, but then they added a little addendum. And that little addendum said, I don't necessarily believe the facts in this, but I think that this case should go forward. Well, query, does that conform to what it says in the canon that the grounds of accusation must be set forth with reasonable certainty, time, place, and circumstances, and that they shall be in writing, signed, and sworn to? What does sworn mean? Does that mean that you just want the process to go forward, or that you actually believe these things? And that was a huge issue in the Ruch case that went up before the trial even started to the provincial tribunal to rule on that. What does the canon actually say? At that time, the provincial tribunal actually had the jurisdiction at that stage to say this is what the law says and means. And the provincial tribunal ruled based on the history, the legislative history, and for other reasons that sworn means you actually believe these things. And we had those bishops actually going up and saying, in some cases, at least one saying to Bishop Ruch, I'm sorry, I didn't believe these things, but I was told the case needed to go forward. Okay, so So there was a huge legal battle in the Ruch case. And this is where the wheels began to fall off. In the Ruch case, the province prosecuting the case did the following things. Number one, they said 4 of the members of Provincial Tribunal should recuse themselves because they know Bishop Ruch, or they have opinions about him, or they've done some work for him. Well, that would render the Provincial Tribunal, a 7-member court, unable to reach a majority decision. So recusal. Number 2, no jurisdiction at this point. It's not fair for them to interfere at this point. Number 3, nothing wrong with adding the addendum because swearing means you don't need to actually believe it. And number 2, the Archbishop has the right to interpret the canon. And of course, this is where checks and balances come in. Do we say to the Archbishop, no, you don't have the right to interpret it that way? Okay. And so this was a very hotly contested case that consumed months of time and thousands of pages of briefs back and forth and oral arguments. And I can testify to that because I was on the tribunal and participated in writing that first decision. Now, interestingly enough, there were objections not to the final decision, even on the rehearing of whether we had jurisdiction or not. There was no objections really to our being able to interpret what the canon said. But there was the belief among some, including the Archbishop at that time, that it was mischief-making by the part of bishops who'd been accused, that they shouldn't be allowed to make mischief and delay justice to the victims by being able to appeal to the Provincial Tribunal. So at Provincial Council 2024, I think it was in Plano, Texas, then Archbishop Emeritus Duncan offered this kind of legislative what would you say, compromise, really. Okay? And so right here, it says, as a court of review, as a court of original jurisdiction to hear and decide matters in dispute arising from the Constitution and canons of the province. And then these words were inserted, except in Title IV prior to the role assigned to it in Clause 1. Was Clause 1 as a court of review. So what that did was remove the original jurisdiction that the Provincial Tribunal had by legislation to hear appeals from accused bishops for help in the process of their case being heard. So the only recourse then that Bishop Ruch would have had he been found guilty is to take that on appeal and then say the court for the trial of a bishop made a fundamental error in the way that it allowed the Archbishop to impanel a board of inquiry without a sufficient investigation, ignoring Bishop Ruch's appeal to have a board of inquiry at a much earlier time respond to rumors, and this whole problem of, was the presentment actually in keeping? Was it sworn as it should have been under the law? So that's a legal dive into a particular case that I will try to summarize in a much shorter way as we move forward. But what I want to say to you about that is that it's illustrative of the problems that we have under the current system of canons. So here's what I want to say to you in preface as I sort of go through the list of bishops that have been charged and either found guilty or found innocent. We have, by my count, 9 bishops who have gone through or are currently going through this process. That's about 1/3 of the College of Bishops. And that is what causes such grief about, are we in fact viable? Are we going to survive? God's clearly doing a house cleaning, but some people have said, well, this shows that the whole system is rotten and that we're going to die, we're going to fracture. Others have said, well, actually the system is working because we have a new legislation in front of us. You'll have to decide for yourselves. But let me go through it kind of in order of how these bishops were charged and explain what the canons did and did not do. So we start with Ron Jackson, who was ultimately convicted of sexual immorality for use of pornography. Now that arose from a rumor that was sent to the archbishop, who then investigated it himself and talked with Bishop Ron. And there was enough there that he confronted Bishop Jackson and asked him to turn over some evidence. The evidence was reviewed by a retired FBI forensic investigator who had experience looking at data, phone records, metadata from computers, etc. There was evidence that some of the devices were destroyed, so that was subject to a second charge of willful contravention of a godly admonition, and he voluntarily submitted to the discipline of the church, because basically at the board of inquiry, the FBI forensic investigator came in and explained to the board of inquiry all the steps he had taken to investigate everything. Okay? So that was really easy, and we thought, okay, well, this is a one and done case, and we didn't have any real loopholes. Yeah, we had to pull together a legal team and help an investigative team, but there wasn't a problem. The wheels began to come off in the Ruch case, and let me remind you what that case was. A lay missioner named Mark Rivera was under the oversight of Bishop Ruch. There was some question about whether he had real oversight or not, because he was part of the greenhouse movement. And so that raised all kinds of issues about greenhouse and about the nature of the diocese and whether it was, in fact, had good canons. Because Mark Rivera is a lay person, remember, the only thing Bishop Ruch could do is turn him over to the authorities, which he did. I mean, he called the police and others investigating this, and then left it at that. He admitted his negligence and apologized and took a voluntary leave of absence. At that point, the ACNA took over the investigation. Bishop Ruch had hired a firm, Grand River Solutions, to actually conduct the investigation. They said, it's not enough. So they went and hired 2 other firms, Hush and Blackwell and Telios, to conduct the investigations. There is some evidence, as you'll read in the trial for the court of a bishop, in Bishop Ruch's case, that the province did not forward all of the evidence, including exculpatory evidence, to the court. And the court decided, because there was some question about that, to exercise what courts frequently do in fact-finding, which is to subpoena the records. That precipitated the then prosecutor in the trial to resign, and the assistant prosecutor to make public statements that were derogatory of the court. And of course, if you read the Ruch trial opinion, you'll find that the court was quite upset at that whole process. But that caused a further delay because you had to all of a sudden find a new prosecutor who could take the case up from that point and carry it through. Ultimately, the court spent as much time detailing the problems the province created in the way it handled the investigation, handled the evidence, weighed the evidence, did not put all of the evidence out there, and then the manner in which the prosecutor simply abandoned the case. It actually set up the grounds in that case for what is now an independent third-party investigation on how the previous administration, up to and including Archbishop Wood, handled the Ruch case, and whether that will result in other presentments against people in the process who committed misconduct remains to be seen. But in the end, what happened is that Bishop Ruch was exonerated. There was no finding of gross and habitual negligence because he dealt with it with the public apology and then got people to help work with him on changing the canons and redressing things. Of course, that left victims feeling of the abuse by Rivera that they were not taken seriously. Mark Rivera was tried in a criminal court and sent to prison, but that was not solace enough for the people who were abused by him. And it was a matter of justice delayed. It took, I think, at least 3 years with all of this back and forth before we actually got to the trial. And that raised the question, is this the best way for us to function in trying cases? So we had, checks and balances going on in the middle of this. The judiciary, the Provincial Tribunal, checking the power of the Archbishop to say what the canons actually say, and the process by which boards of inquiry are called or should not be called. We had the legislative then correcting the decision of the Provincial Tribunal and withdrawing some of its original jurisdiction. Okay? While all of this going on, there was another bishop that was brought before the Provincial Tribunal by a priest. His name is Steve Breedlove. And Bishop Breedlove was investigating allegations against a priest in his diocese. And he hired an investigation team that completely botched the investigation. They didn't find facts. They were pastorally very sensitive, and so they gave lots of pastoral opinions, but they didn't actually get to the facts. And so there wasn't much for Bishop Steve to do with this priest except give him some things he had to do to make sure that he was much more pastoral in the future. But not satisfied with that, he and the standing committee wanted him to go forward and conduct a new investigation. And the priest said, double jeopardy. I've already been investigated. You can't do it again. I've been given a program. I've done the program. And that case went up to the Provincial Tribunal. And the Provincial Tribunal said, well, we don't have double jeopardy. But as a matter of fairness, we're going to say, no, you can't have a second investigation. What's done is done. That's it. Okay. So then the court for the trial of a bishop, you have the verdict in the Ruch case, plus a great critique of the Anglican Church in North America and the way it handled things under the existing canons. Then you had another bishop named Todd Atkinson. Todd Atkinson was outside the ACNA. He was running a diocese called Via Apostolica, and he was overseeing churches both in Canada and in Kenya. And credible allegations of grooming, spiritual grooming, emotional grooming of the children of clergy, particularly female children, and the wives of clergy came forward. And so presentment was brought against him. And there is a long over, I think it's almost 100-page opinion, but they conducted an investigation. And all of the depositions they took, I know, were and investigative reports of all of the witnesses. I think there were about, and then all of the motions that were filed by Bishop Atkinson's attorneys. It's about 10,000 pages. And so for almost an entire year, this body of 7 judges plus a canonical advisor who is a dear friend of mine were completely overwhelmed time-wise in doing this case. To their great credit, they made factual findings on every one of the allegations. They said, we investigated this. Here's how we weighed the evidence. We determined that he did commit this offense. And that has become a model for our moving into what we call a much more inquisitorial than adversarial model. Now, in our canon law class, we look at that model because it's very different than the adversarial process we're used to. The adversarial process assumes, in a kind of a secular way, that instead of allowing people to go out and duel and whoever wins must obviously be the one in the right, we're going to have structured violence in the courtroom. And we're going to do it in such a way that we allow people to make motions and objections and cross-examine and do all kinds of things, and oftentimes use the art of litigation rather than to find the truth, to win. And in some ways, there's good to that process because ultimately there is a belief that truth will win out. But then sometimes it doesn't, because sometimes money wins if you paper your opponent to death. And in the Atkinson case, not only did Atkinson try to paper the province to death, but every time he lost, he changed attorneys. So we had to reset the clock and start all over again. And finally, it went up to the Provincial Tribunal, and they said, I'm sorry, you missed the deadline. Trial goes forward. And it went forward, and we have this model. And so the model that we are looking at, the paradigm, if you will, behind the new legislative shift in Title IV is an inquisitorial model rather than an adversarial one. And the idea is that instead of letting the attorneys determine what evidence the fact finders actually see, we leave it up to the judges. And so instead of having a big, long trial that could last for months or years, you have the presentation of evidence on the basis of documents. And the proctors on either side will submit that, and then the court will decide, that 3-member panel, remember, bishop, priest, and layperson. And let me just say, instead of just priest, bishop, clergy, it could be a deacon, and layperson, that 3-member panel will decide, okay, is this sufficient for us to proceed, or what other evidence do we need? And that is going to become a much more efficient and fact-finding focused way of getting to the truth. I would argue that it actually honors what it means to walk in the light and not hide things. Now there's, of course, still adversarial elements in it. You know, it provides that if you're a proctor, essentially a canon lawyer in this process, and the court says, I don't need that evidence, I don't think it's relevant, or it denies your offering more evidence, you could take that up to the Provincial Tribunal and have them rule on it. but it'll be a much faster process than it would have been under the existing canons. So this is what gave rise to the formation of this new Title IV process. Now, the final cases that remain that I can comment on are the presentments against Derek Lyons, and I believe that there will be included those bishops that were his suffragans, Bishops White, Nordstrom, and the new suffragan, Bishop McClanahan. And those really have to do with the way, first of all, that he treated chaplains, and there's lots of evidence that there were patterns of behavior of possibly even bullying chaplains over requirements to tithe to the special jurisdiction. There are larger structural issues of not telling the bishops that he had incorporated the jurisdiction of the armed forces as a separate 501c3 over which he had complete control and was not in compliance with the canons of the special jurisdiction. And then there's the personal issue of comments he's made derogatory towards Bishop Julian Dobbs that Julian Dobbs and others have answered, but which he continues to make publicly. So all of this is in the end going to come under what the executive committee, which is the vestry of the province, has authorized an independent third party to come in and investigate all of this that has happened. They are interviewing people already, and they're going to deliver a report, presumably to the executive committee and to the College of Bishops, on where people made errors, where offenses may have been committed, and we'll have to wait and see how that transpires. So let me pause there and see what questions, if any, you may have that I can answer about all of these. Oh, Derek Jones, not Derek Lyons. Yes, that's right. Derek Jones. I don't know why I said Derek Lyons. Okay. All right.
The question, in what ways can we as a laity assist in the ecclesiastical discipline process?
Yeah. So the question is, in what ways can we as laypersons participate in the ecclesiastical disciplinary process? Number one, pray. Pray. Pray for everyone who is involved in the legislative process and the correction of our canons. Secondly, be informed. And that is, look at the new Title IV, compare it to the old Title IV, the current Title IV, and make up your own mind about what seems best to you, and write. You're invited, the province invites you to write in and give comments about the whole process. Number three is that you have opportunities to serve in your diocese. And among the ways that you can serve in your diocese is your willingness to serve on the court for the trial of a bishop. If you have any prior law enforcement experience, any secular experience in conducting investigations in an objective way, face-to-face interviewing people, particularly if you're in that latter category, please see me or our Chief Administrative Officer, Connie Polite, because we always need people who have the time and willingness to conduct objective, fact-finding investigations. If you have a desire to see justice done in a fair and impartial way, consider contacting me about serving on the court for the trial of a bishop. We need to of the court for the trial of a presbyter or deacon. We need to staff that court. And that's going to be one of the things that we do when we meet for synod in October. If you want to serve on one of the trial courts, on the reports investigative committee, the reporting investigative committee, or as a proctor, and you're a layperson, let me give you a couple of suggestions. Number one, once Title IV is passed and you want to serve, let's say you have a legal background, you want to serve as a proctor, take the class that I offer through Trinity on Introduction to Canon Law, because that's going to be a basic requirement for people serving in the process. If you want to be part of an investigating team, let me know and I will forward that on to the provincial office. But there are ways that you can serve, and if God is moving you to serve, please let me know. The question, are canons fluid and subject to change, or are there parts of our canons that are sacrosanct and can never be changed? Well, that's a great question. I would say that there are very few canons that can't be changed. Constitutionally, I think we've got, to borrow a phrase from Saturday Night Live, I think we have two lock boxes in our own Constitution. One is with regards to property. The other is with regards to women in holy orders. The constitutional provision that allows dioceses to determine whether women will be in holy orders is one that would have to be overturned by a supermajority of people in both provincial council and in provincial assembly. And it would have a 90-day window for people to leave the province before it actually goes into effect. And so it's sort of the doomsday clause. If we ever say mandate one way or the other, it would force some people to leave, either those who are in favor of women's ordination or those who are against. Likewise with property, there would be a major uproar if we change the constitutional provision that says that the local church and its buildings are owned by the people and not by the diocese or the province. You try to change that, and I guarantee you, I don't know how many people will leave the ACNA, but everything else is up for grabs, if you will, which is why we've gone into this extraordinary amendment process of our church discipline Title IV. And the reality is that the constitutions and canons commission of the ACNA is going to be receiving every year, as it did for every year since we formed, suggestions for filling in gaps, for adjusting canons to circumstances on the ground, and for making whatever amendments we need to make. So it will be a constant process, just like our own legislative processes are. Canon Joyce.
Once the provincial assembly has both of its same canon, is it a done deal for it to have to wait period until we can? What is the process?
So the question is, once the provincial assembly votes, let's say, to ratify the provincial council's determination and affirmation of new Title IV, is there any more subsequent voting? And the answer is no. And you see, normally, if we were doing this in the normal legislative pattern, we would address this at Provincial Council 2025 in or 2026 in June. And then we might have to wait a whole year for a provincial assembly, because you only have a provincial assembly, which is a much larger body on the basis of total population of your diocese. And that only happens twice in a 5-year period, okay? So we looked at the canons, the College of Bishops did, and we found that, there's no reason you couldn't have a provincial assembly that actually meets by Zoom and can meet within a much shorter period of time, focused on just affirming Title IV. And that is exactly what's going to happen. New Title IV, there may be a few more tweaks and adjustments if there is permission for that to take place on the floor. And that raises a whole other issue about the way we've been doing legislation. But if it is passed by provincial council, then I think it's 60 days later or something like that, maybe even less time. Provincial assembly will meet by Zoom, and they will affirm or not the new Title IV, and then it will go into effect within 90 days, according to the canons that we have, if not sooner. And that is the fastest way we can get it into place.
Does the vestry of any systemic church have a role in its assessment process involving clergy within their church?
Yes. So there's two ways the vestry may be involved in a particular case. Sometimes the action of the clergy doesn't constitute a canonical offense. But I know that some bishops have said, terminal stupidity by clergy is not an offense, but it can sure wreck the relationship with the vestry. And so we actually have canons under Title III regarding ministry that say, what do you do when the relationship, the pastoral relationship between the rector and the vestry is impaired? And it outlines a process that everybody has to go through, and it brings the bishop into it. And the vestry is very involved. And I commend that to you. Look that up in the canons. Now, if there is an offense, and under the current canons, there's enough credible evidence for the bishop to step in and either give a godly admonition or an inhibition to the clergy person, or even if there's a trial pending, the vestry will no doubt be consulted by the bishop, and he'll have an opportunity to ask questions and offer evidence either in support or mitigating the charges leveled against the clergy person.
Regarding the Derek Jones matter, and someone's asking, it looks as though the prosecution is operating under new Title 14 versus the current Title 14.
Yeah, the question is, it looks like the case against Derek Jones is operating now under new Title IV rather than our current Title IV. If that is the case, I don't know for sure. I think you could certainly make an argument by virtue of, you could make an argument either way. And here's the complexity in the Jones case, because Derek Jones has said, I've left the ACNA. They're a terrible bunch of people and I don't like them and I'm starting my own denomination. So question arises among canon lawyers, Well, since he's left, does he actually have any standing, since he's no longer a member of the Anglican Church in North America? Does he have any standing even to be represented in court? Do we try him in absentia, or do we graciously allow him, even though he says he's left, to be in court? To the question, isn't there some way to discipline them? Almost everybody we interview doesn't need to be fenced from the table. They are all good and godly people. Their character is not really at issue. The question is whether they are called or not. And it may be they lack certain skills or qualities of character or vision or understanding of the office of the holy orders that they are seeking. And that's why we have discernment not only by the rector first, and then by the parish discernment committee, and then with psych evals and marriage evaluations and transcripts of education, et cetera, et cetera. But that's why we gathered, 27 people or so for 9 aspirants, to have them, people who may not have interviewed them ever before and not even know them, have some objective eyes to say yes, no. So it's not so much a question of discipline. They're under the same discipline as a layperson would be, but rather, are they called or not? And Bacchum is a truly conciliar way of our involving the whole church, addressing something that touches the whole church, because we want everyone who becomes a postulant and then a candidate for ordination to be able to serve not just in their local church, but anywhere in the diocese. So that's why we do what we do. And I know one last question probably on everybody's mind: is there a future for the ACNA? How are we going to move forward together? Here's my response on that. There will always be sin in the church. Jesus talked about this in the parable of the wheat and the tares. And there's a certain sense in which we live with that, and there's going to be a final judgment. In the meantime, we can make sure the wheat is growing as well as it can and is not being choked by the weeds. But I go back to another place in Scripture, 1 John 1, 7 through 9. This is at the heart of the East African revival. And this passage is at the heart of the renewal of the Anglican Church all over the world, globally and here in North America. And that is, if we walk in the light as He, that is Christ, is in the light, we have fellowship with one another, and the blood of Jesus cleanses us from all sin. If we say that we have no sin, we lie, and the truth is not in us. But if we confess our sins, He is faithful and just to forgive us and to cleanse us from all unrighteousness. I'm old enough that I remember the days in kindergarten where we had that awful grainy paper with the blue dotted lines in between the two lines, and we had to do our letters and write them plain and in cursive. And when we got it wrong, we erased it and we put something new in, but you could always see the erase marks, right? And what Jesus says through the Apostle John in that is, you don't get the old paper, you get a fresh piece of paper. That's what cleansing from our sin is. But it does require acknowledgement of the facts of sin. It requires transparency. And it requires being a true disciple of Jesus. I think we are in a period of house cleaning because God is preparing us for some difficult times in mission, and we will need to be as bright and scandal-less as we possibly can be to have the kind of credibility to share the transforming love of Jesus Christ. And that is why what we've been talking about in these spring lectures is so important. So please pray for yourselves, for our diocese, for your bishop, for the College of Bishops, for all of ACNA, that we may take those words from 1 John 1, 7 through 9 to heart and submit ourselves to whatever confession, whatever truth-telling, and whatever cleansing we need so that we can have the fellowship that Christ promises us when we do so. Amen?